Miss Patty, can you hear me?
Yes, ma'am.
Oh, I can't hear you. Call me on your cell. Hey, I have Mr. Waldron
Can't
here.
hear. You have Mr. Waldron there?
I can't hear you.
I need.
Well, I don't know why.
Can you call me on your cell phone?
Taylor. Powell. Taylor.
Why can't you hear us? She has one guy that's in U.S. Marshal custody and one that's at Wood County. So he can either stay there and Zoom or he can come out here. They're supposed to Zoom at 1:45 from Wood County. 2:00. How ours is. Yeah, because we have Wood County and Henderson County this afternoon. Wood County's first at 1:45 and then Henderson County's supposed to be at 2:00. Hey, yeah, I don't think that would be us, because we're jail court, so. Okay, all right.
Remind me of your name, sir.
Kerry Sanders.
All right, Mr. Sanders, Mr. Waldron is here. He's out in the hallway. He's about to come in. Just hold tight and we'll get going in just a second, okay?
Yes, sir.
All right, thank you. All right, court calls number CR 22-392, State of Texas versus Kerry Lynn Sanders. For docket call, Mr. Sanders is appearing via Zoom from the Wood County Justice Center. Any announcements on docket call, Mr. Waldron?
Yes, Judge. I just spoke with Ms. Curry regarding Mr. Sanders' case. I think we have a deal in place. I've been discussing with Mr. Sanders. And if we could set him for a plea, and we'll have to get him bench warranted over from Wood County, but I anticipate that that's going to be a plea here in the next week or so, or whenever the court has available.
I've got a couple dates in December. Well, let's see. If you want to do it in a couple of weeks, I could do it on November 26th. That's one potential date. And then also got December 5th. It's a Thursday.
Let's do December 5th.
December
That would
5th?
work better.
Okay, that'll give us some time to get the bench warrant out.
That's right.
All right, Mr. Sanders, I'm going to set you for December 5th, and we'll get a bench warrant over to Wood County to get you authorized to be brought to Van Zandt. And Mr. Waldron will be here that day.
All right, thank you.
All right.
All right.
All right. Tell the people of Wood County I appreciate their help today.
Yes, sir.
All right. Thanks, sir. Have a good day.
You too.
He served his 18-month sentence in federal. Also talked to Ms. Curry. I think we have a deal in place on Mr. Edwards, so we'll have to bench him over also. So if we want to set him for a plea on that same day.
All right. And cause number CR 24-39, State versus Ronald Jack Edwards. The court will set Mr. Edwards for plea before the court December 5th at 1:30. And I will get us a bench warrant sent over to Smith County.
Sounds good.
All right. Is that all you have today?
That's all I've got.
Free to go.
Thank
See
you,
you.
Judge.
Is there anything?
He's got her.
Hey, got a minute? Okay, so I'm over in the, library.
That video, I muted it accidentally. I've asked Henderson County to turn on, but they're not, so I guess we'll just wait.
Okay, well, we're ready to start with the others.
Tell Mr. Smith.
All right.
This is what I get.
Your Honor, can you say something?
So,
Something one more time?
something one more time. Is it not working?
We don't hear you very loudly.
I
Can
bet
you
do.
hear me now?
I bet you do now.
Oh, yes, sir.
Yes, sir, Mr. Wilson, we can hear you.
Okay, thank you. Sorry.
It's okay. It's okay. It just takes a moment to get these things hooked up. Mr. Schmidt's about to step into your frame there in just a second. I'll go ahead and call the case. It's cause number CR 23-83, State of Texas versus Preston Mitchell Wilson. For status, court will note that Mr. Wilson is appearing on Zoom from the Henderson County Jail. Go ahead, Mr. Schmidt. Any announcements?
Judge, we've been in a holding pattern. The state was considering the status of their case based on I believe, a federal indictment. I'm unaware of the status of that, and I'm unaware of the state's position at this time.
State.
Your Honor, I don't have see an update. I can see if I can figure something out the next little bit here, but I don't have a note for it.
Okay. Well, I don't want to hold the jail over, so I'm going to go ahead and reset it, but we do need to get a definitive answer from the state on what it wants to do on its prosecution. All right, court's going to reset Mr. Wilson for another status on December 17th. That'll be at 1:30, and Mr. Wilson will make arrangements to have you zoom in again.
Okay. Okay, sir.
Right.
Thank you.
So you understand
Sorry.
what's going on?
Yes, sir. Maybe y'all can, my lawyer's name is Kenneth Robert Hawk. He's probably pretty busy, but I think if he could be notified, he could probably clarify a lot of things, what's going on. I mean, I could tell you all day long, but he's my lawyer.
Sure. We appreciate that, and since you said that, I'm sure the state's written that down along with the defense attorneys.
I have not final pled here, but it's imminent, I'm waiting for my PSR to return and then schedule a court date to plea out on what I have here in federal custody.
Okay, well, we'll try to dig into that and figure out what we have, but we'll try to get you back on the 17th and maybe we can get that nailed down.
Okay, sir.
All right. Thank you, Mr. Wilson. Have a good day, sir.
Thank you. You as well.
Tell the jail staff I appreciate them.
Okay, thank you.
You bet. Have a good day. All right, Mr. Hind, who would you like next?
Timothy Simpson.
Mr. Simpson, if you'll come forward, this is cause numbers CR 24-32, 33, and 34, State versus Timothy Lane Simpson. And we're gonna be doing a play today, is that correct?
That's correct.
All right, Mr. Simpson, sir, if you'll raise your right hand, I'm gonna place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Timothy Lane Simpson II, is that correct?
Yes.
And Mr. Simpson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition? All right, in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you have any questions about your plea agreement or anything else?
No, sir.
All right, Mr. Schmidt, do you believe Mr. Simpson to be competent? And if so, have you explained to him his rights regarding this case?
Yes.
All right, Mr. Simpson, you are charged by indictment with a forgery of a financial instrument greater than $2,500, less than $30,000. I believe that's a state jail felony. However, the state, I believe, has alleged prior criminal convictions as enhancements that, if found true, would elevate this range of punishment to that of a second-degree felony, which has a minimum 2 years to a maximum 20 years in prison and a fine not to exceed $10,000. I see the plea agreement in your case is upon your plea of guilt, the state is recommending that the court assess your punishment today at 4 years confinement in prison with a $1,000 fine plus restitution of $180, court costs of $290, and reimbursement fees of $140. And you would receive today time credit of 309 days towards your sentence for the time that you've already spent in jail on this cause. Yes, sir.
Judge, we revised the judgment I have in my hand. It's 390 credit days.
390,
Yes, sir.
and that's agreed by the state.
Yes, sir.
Okay. So is that just a typo, or did y'all find 81 more days?
We found 81 more days. Yes, sir. I confer with Ms. Abney.
Okay. All right, then, Mr. Simpson, you would receive 390 days credit towards your sentence for the time that you spent in jail on this cause. Mr. Simpson, I would ask you, having explained to you the plea agreement and the range of punishment, is that your understanding of the plea agreement and what you're asking the court to approve?
Yes, sir.
All right. So, Mr. Simpson, at this time, how do you plead to forgery of a financial instrument?
Guilty.
And how do you plead to the first enhancement paragraph? Is that true or not true?
True.
And how do you plead to the second enhancement paragraph? Is that true?
True.
All right. And Mr. Simpson, are you entering these pleas because you're guilty of the offense and each of the enhancement paragraphs allegations are true?
Yes, sir.
And has anybody threatened you, forced you, or pressured you to plead guilty or true to these allegations?
No, sir.
All right, then the court will accept the defendant's plea of guilt and pleas of true to each enhancement paragraph. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, there being no objection, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
And if I didn't reside in the plea agreement, I also find that there's an agreement that the two indicted causes, CR 2434 and CR 2432, would be dismissed in conjunction with two unfiled cases of possession of controlled substance and a tampering or fabricating with physical evidence. Mr. Schmidt, let's see. Oh, I do have a stipulation. All right, the court having Consider the evidence, finds enough evidence to convict Mr. Simpson of this offense. The court will follow the plea agreement and the recommendation of the DA's office. The court hereby convicts Timothy Lane Simpson II of forgery of a financial instrument greater than $2,500, less than $30,000. Court finds that enhancement paragraphs have been alleged. The court finds each enhancement paragraph to be true. Court finds that the increased punishment range is that of a second-degree felony. The court assesses punishment pursuant to the plea agreement at 4 years confinement, in the Texas Department of Criminal Justice Institutional Division orders Mr. Simpson to pay a $1,000 fine, $180 restitution, $290 court cost, and $140 in reimbursement fees. Furthermore, the court dismisses cause number CR 2434, CR 24-32, and unfiled cases of possession of controlled substance and tampering or fabricating with physical evidence under section 1245. And the court awards Mr. Simpson 390 days towards his sentence for the time that he has already spent in jail on this cause. Mr. Simpson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted with a deputy. Once you're released from prison, if you've not paid off your fines, court costs, reimbursement fees, then you'll need to report to the Bennington County Courthouse and make arrangements to do so, lest a warrant may be issued for you, okay?
Yes, sir.
All right. You'll step over to be fingerprinted.
This is Nicholas Fincher.
Mr. Fincher? All right, this is cause number CR 20-118, State versus Nicholas Christopher Fincher. Mr. Fincher, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Just make sure you speak up loudly and clearly for me. All right, Mr. Fincher. You were before the court back on December 15th of 2020, and you pled guilty to possession of a controlled substance between 4 grams to 400 grams, a second-degree felony. The court heard the evidence that day and then followed a plea agreement that you made with the state of Texas. The court deferred a finding of guilt and placed you on probation for 5 years. Your probationary period was then extended for an additional 2 years in 2020. Well, it was extended to go through December of 2027. It's been during your period of community supervision that the probation department and state have filed their motion to adjudicate and revoke your community supervision. And in that motion, they have alleged 4 separate counts of various allegations of violations. Have you had enough time to read over that motion to adjudicate and revoke with your attorney, Mr. Schmidt?
Yes, sir.
Do you understand everything that you've agreed to in your plea agreement?
Yes, sir.
Do you have any questions for the court or Mr. Schmidt or anything further? Go ahead, Mr. Schmidt.
For the court's information, Mr. Fincher intends to plead true to counts 2, 3, and 4. And the state had agreed previously through Mr. Hartwell to abandon count 1. And that's reflected on the judgment.
All right, thank you, Mr. Schmidt. All right, and Mr. Schmidt, you believe Mr. Fincher to be competent, and if so, that you've explained to him his rights regarding this case?
Yes, sir.
All right, Mr. Fincher, I see the plea agreement is that upon your plea of true to counts 2, 3, and 4, the state's recommending to the court that the court adjudicate your guilt. That means to convict you of that original offense, to revoke your original community supervision, and punish you at 4 years confinement in prison, and also ordering you to pay the remainder of your fines and reimbursement fees. And you would receive 110 days credit towards your sentence for the time in jail. Is that your agreement today, Mr. Fincher?
Yes, sir.
All right, then, Mr. Fincher, how do you plead to counts 2, 3, and 4 as alleged? Are those counts true or not true?
It's true.
And you're admitting that each one of those is true because, in fact, what's alleged in there is true. Is that right?
Yes, sir.
And Mr. Fincher, has anybody threatened you, forced you, or pressured you to plead true?
No, sir.
All right, court does accept the defendant's pleas of true to the counts 2, 3, and 4. Mr. Schmidt, any objection to the defendant's waiver of rights and plea of true being admitted in evidence?
No objection.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then, based on the evidence, the court finds that Nicholas Christopher Fincher has violated the terms and conditions of his community supervision. The court finds counts 2, 3, and 4 to be true. The court hereby adjudicates his guilt and revokes his community supervision pursuant to the plea agreement at 4 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders him to pay the remainder of his fines, court costs, and reimbursement fees. And the court awards Mr. Fincher 110 days credit towards his sentence for the time that he's already spent in jail on this matter. Mr. Fincher, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from prison, make sure that if you have not already paid off your fines and reimbursement fees, that you report to the courthouse and take a payment plan or something and get that taken care of, okay?
Yes, sir. Thank you.
All right, good luck to you. Step over and be fingerprinted. Who's next?
Michael Powell.
Mr. Powell, if you'll come up, sir, this is cause number CR 24-146. All right, Mr. Powell, sir, if you will, this is, if I haven't already said it for records, cause number CR 24-146. Mr. Powell, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Powell, you are Michael Ray Powell Jr., correct?
Yes, sir.
And Mr. Powell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done?
Yes, sir.
Do you have any questions about your plea agreement or anything else?
No, sir.
Okay, Mr. Schmidt, do you believe Mr. Powell to be competent? And if so, have you explained to him his rights as they pertain to this case?
Yes, sir.
All right, Mr. Powell, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. A third-degree felony does have a range of punishment of not less than 2 years in prison or more than 10 years in prison, and carries an optional fine not to exceed $10,000. I see the plea agreement in your case is that you will plead guilty. The state recommends that the court convict you after reviewing the evidence and assess your punishment at 2 years in prison with the assessment of a $1,000 fine, $290 court cost, $180 restitution, and $35 in reimbursement fees. In addition, the state would be also dismissing an unfiled evading arrest or detention case, and you would receive 730 days credit toward your sentence for the time that you have spent in jail on this cause. Is that your understanding of the plea agreement, Mr. Powell?
Yes, sir.
All right, understanding all of those things, Mr. Powell, how do you plead to possession of a controlled substance group 1 between 1 grams and 4 grams?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, then the court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
No, sir.
All right, then the court's going to review the evidence. All right, having reviewed the evidence, court finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement. The court convicts Michael Ray Powell Jr. of possession of a controlled substance, a third-degree felony, assesses punishment at 2 years confinement in the Texas Department of Criminal Justice, Orders him to pay a $1,000 fine, $290 court cost, $180 restitution, and $35 in reimbursement fees. Furthermore, the court awards Mr. Powell 730 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Powell, once you are released from TDC, I need you to report back to the courthouse to take care of your fines, restitution, court costs, and reimbursement fees. Failure to do so may result in the court issuing a warrant for your arrest, okay?
Yes, sir.
All right, any questions?
No, sir.
All right, step over to be fingerprinted. Who's next?
Andrew Holden.
Andrew Wayne Holden, CR 24-100. All right, Mr. Holden, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You can lower your hand. All right, Mr. Holden, you were originally charged with a second-degree felony offense of aggravated assault with a deadly weapon. It appears today that the state's recommending that the court accept a lower, lesser offense of Class A misdemeanor assault causes bodily injury of a family member. Mr. Holden, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition? You're represented in this case by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done?
Yes, sir.
Do you have any questions about your plea agreement? No? All right, Mr. Schmidt, do you believe Mr. Holden to be competent?
I do.
And you've explained to him his rights pertaining to this case?
I have.
All right, Mr. Holden, the range of punishment for a lesser offense of a Class A misdemeanor assault causes bodily injury of a family member is confinement in the county jail up to a maximum 365 days and a possible fine, which cannot exceed $4,000. I see that the plea agreement you're asking the court to approve is that you would plead guilty to that lesser offense of Class A assault causes bodily injury of a family member. The state's recommending that the court consider the evidence, convict you, assess your punishment at 1 year in the county jail, but with that sentence being suspended and you being placed on 2 years of probation, community supervision. And that would include a fine of $750, court costs of $270, and reimbursement fees of $535. Is that your understanding of the plea agreement, Mr. Holden?
Yes, sir.
All right, understanding all of those things, Mr. Holden, then how do you plead to Class A misdemeanor assault causes bodily injury of a family member?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anybody threatened, forced, or pressured you to plead guilty?
No.
Court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, sorry, I normally check ahead of time to check for the victim input, if the court will bear with me for just one moment.
Yes, sir, go ahead. Mr. Schmidt, anything further from the defense?
No, sir.
And Your Honor, victim impact statement was sent out to the victim, was not returned, and follow-up attempts were unsuccessful.
Okay, thank you, Mr. Harlow. I'm not sure if I have that stipulation. I don't see it. Mr. Schmidt, is there any way you could display that to the court, please, sir?
Yes, sir. 1 second.
Thank you. Perfect, right there. All right, thank you, Mr. Schmidt. All right, the court having reviewed the evidence finds sufficient evidence to convict the defendant. The court will follow the plea agreement and recommendation of the DA's office. The court hereby convicts Andrew Wayne Holden of Class A misdemeanor assault causes bodily injury. Family member. assesses punishment at 1 year in the Van Zandt County Jail. The court will suspend that sentence and place Mr. Holden on 2 years community supervision. Orders him to pay a $750 fine, $270 court cost, and reimbursement fees of $535. Mr. Holden, you're hereby, court will also dismiss unfiled DA cause 2024-302, a terroristic threat. Mr. Holden, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Once you're fingerprinted, then the probation officers will tell you about what's next, okay?
Yes, sir.
Who's next?
If I could make an announcement on Brandon Creel.
Yeah, let me call that real quick so I can get it on the record. This is cause number CR 23-158, State versus Brandon Ashley Creel. And I believe that we were set today on status competency. Are you waiving his appearance here today or?
I am for today, Judge. He's still incompetent. It's my understanding that he's being compliant with his meds and that his behavior has improved. I asked the jail not to bring him. If we could reset him, and then we might be able to fix the competency issue.
Okay. You want to set sometime in January?
I think under the circumstances, December would probably be more likely to be successful.
All right, court sets Mr. Creel for December 17th. And we'll just do another status of competency. December 17th at 1:30. And that's in both cause numbers CR 24-206 and CR 23-158. Who'd you like next?
Jeffrey Mills.
Jeffrey Alden Mills, CR 21-229.
Judge, previously we've announced ready for trial on Mr. Mills. I filed a motion for bond reduction, and that's what we're set for today. I didn't organize myself well enough, and I explained to Mr. Mills that I'm not prepared to go forward with this motion, and I'd like if the court would allow us to set it on Thursday afternoon. I'd also like an opportunity between now and then to talk to Mr. Hartwell about it, and I intend to do that, but drop the ball.
On Thursday of this week, the 14th?
Yes, sir. Yes, sir.
Okay. Any objections from the state?
No, Your Honor, thank you.
All right, then the court will set Mr. Mills for hearing on his motion to reduce bail Thursday, November 14th. That'll be at 1:30.
Not there yet. But I haven't worked out. Well, you're okay today. We're not doing anything today, but so. Okay. If I can find out, that's okay. So
Who's next?
this is Jacob Paul.
All right, this is cause number CR 24-136, State of Texas versus Jacob Thomas Hall for docket call. Go ahead, Mr. Schmidt.
And Judge, we were on a quick reset from our prior setting. I was optimistic that I could squeak in and meet with Mr. Hartwell, and we're making progress towards a resolution. There's some holdups but due to the state being in trial and me being elsewhere, I was unable to do that. So we're like another quick docket call setting.
You want to do beginning of December?
Yes, sir.
December 3rd?
Yeah, that'll be fun.
All right, court sets Mr. Hall for docket call December 3rd at 1:30. Who's next?
This is Dustin Hall.
All right, State of Texas versus Dustin Lee Hall, cause number CR 21-385. It's on the motion to revoke, I believe. Go ahead, Mr. Schmidt.
That's correct, Judge. Mr. Hall is here on a bench warrant. Last Friday just got here, so I haven't had an opportunity to meet with him. Though. See if we can't reset that.
Do you want to bump him over to the 26th?
Yeah, we might as well.
Okay. All right, court sets Mr. Hall for November 26th at 1:30.
John.
Who's next?
John Dickerson.
Cause number CR 24-180. State versus John Franklin Dickerson for pretrial. Go ahead, Mr. Schmidt.
Judge, we don't have any contested motions at this point in time. That's for a docket call setting.
All right, there being no contested pretrial motions, court sets Mr. Dickerson for docket call December 17th at 1:30.
Right there. 12, 17.
Ready on Mr. Taylor?
Judge, we have a plea almost prepared. There's some questions about his credit time. There's been a lot of different things going on with Mr. Taylor. I can't sort it from here. I'll be more than happy to reset him for Thursday if you want, see if we can't sort that out. He's happy with that. I just hold on to the paperwork. The only holdup is figuring out the credit time, and it's all over the place.
Mr. Charwell?
No objection to resetting, Your Honor. Want to make sure that he gets all the credit time he's entitled to.
All right, court will reset Mr. Taylor for Thursday of this week, November 14th for plea.
Thank you. Man.
Your Honor,
Yes, ma'am.
that concludes our business. We hope.
I think so. I don't see anything else, so. All right, that concludes our afternoon docket. Board is adjourned for the day. Thank you, Mr. Schmidt.
Good.